Morning.
Good morning. May it please the court, Kara Broad-Rockenbach on behalf of the Palm Beach County Sheriff's Office and Sheriff Rick Bradshaw. I'd like to reserve 2 minutes for rebuttal. The judicial system survives by the participation of witnesses. This court must protect the identity of the murder witnesses, 2 of them, who actually were good citizens, and also protect the public at large by applying the exemption to the public records law. There are 3 compelling reasons why this court should reverse the trial court's order compelling this identifying witness investigation information. Number 1, there would be a chilling effect. If you consider no one would ever come forward. As Captain Wallace testified at the hearing before the trial judge, he said,
most witnesses or victims of crime know the law and disclosure and are going to modify their behavior based upon whether or not they're within the exemption or exception to the exemption of the public records laws?
I think there's probably, I know in this case, the 2 witnesses, as Captain Wallace testified, are petrified. The word is petrified in the record.
No, but what you're saying is we want to encourage people to report, and that assumes that people have knowledge of the public record laws and are going to make their decisions based upon whether or not they would allow disclosure. That seems like a kind of a specious assumption, isn't it?
I think it might be specious to
people are
presume that they
to know the law, so.
But they might. But I think it's fair to presume that witnesses believe that law enforcement's going to protect them. Captain Wallace testified at the hearing below. If their identifying information is released, we cannot promise protection, and that is what has them absolutely scared in this case.
But sure, I understand
the concern that they wouldn't know that there's an exemption to the broad public records law.
This exemption applies to witnesses, but it doesn't apply to victims.
That's correct, Your Honor.
So these witnesses were not victims of the murder, but they were victims of the attempted murder, which occurred after the murder.
That's correct. It's an aggravated assault crime,
And there was a break of time. It wasn't as if the shooter shot the victim and then started shooting at the 2 witnesses immediately after that. I think they started to follow.
Absolutely.
They started to pursue
Correct.
So that's when they became victims.
They are not victims to the murder. That's correct.
And we're talking about disclosing only them as witnesses in the murder.
And here's the problem, and I appreciate the question because it seems to be one of a sequential time sequencing question. There really is no break because the murder occurs, these 2 witnesses observe it, and by gosh, they put on their good citizen hat and say, we're witnesses, we're going to help law enforcement. They pursue this driver, the murderer, on I-95 in broad daylight, and become witnesses immediately. They had no idea the guy was going to lean out the window and start shooting at them. So
if we ruled for you and found that they're not victims of this crime, couldn't the newspaper just come back and make a second request and say, give us the names of the victims of the aggravated assault crime?
And that's
that was later, so that's not going to get you anywhere.
It isn't, and the problem is that the public or this murderer can connect the dots. He knows when he did the shooting. It was February 9th of this year. So if the newspaper's reports, and they're in the record in the appendix, the 2 articles, I think I cited in my reply brief, if it bleeds, it leads, the newspaper maxim on public information, they're not reporting on the shooting of these witnesses, they're reporting on the murder. That's what's leading this and driving the disclosure of their identifying information. And what's problematic is that Sun-Sentinel wants this court to say, as they convinced Judge Haffel below, just ignore the fact that they're murder witnesses. But you can't. There's nothing in the public records law, the exemption or the exception for victims, that says once they become victims, they're no longer murder witnesses. That is, they keep that protection and that cap of protection, that cloak, until the statute of limitations on murder expires, or until it's no longer an active criminal investigation, which is the key term.
So you want us, which is kind of what I was getting at, is that even though there was this break in time, temporal break in time between the murder and the attempted murders, you're suggesting that both incidences are privileged under the exemption.
I'm
It
saying
cannot be disclosed.
I'm saying that it is far too dangerous to say that there was a break and that they can't still have the cloak of witness protection just because they then become victims of a lesser crime. It's all one sequence, and it all stems from the murder. They would not have become victims had they not pursued their good citizen role of investigating this crime as murder witnesses. They weren't going to be randomly shot at.
Is the perpetrator or perpetrators still at large?
Yes, and dangerous, armed and dangerous, according to Captain Wallace's testimony that was unrebutted.
Let me ask this. When then is it the sheriff's view that the quote-unquote active criminal investigation, in this case an active homicide investigation, would come to a conclusion to the extent then that the Sun-Sentinel would be entitled to this information?
That's a great question. And I think we cited some cases in the briefs about the statute of limitations and that the active criminal investigation, there was one case that a newspaper wanted that information saying, it's getting stale, we want the information, it's no longer active. They were challenging the good faith of the agency from protecting that information. And the appellate court, I think it's the first DCA, said, this has only been 4 months, and there's no evidence that it is not an active, ongoing criminal investigation. This happened in February. The testimony of Captain Wallace was completely unrefuted, completely unrebutted. Active criminal investigation. We now, thanks to these two witnesses, have a sketch of the perpetrator, the murderer, and are actively trying to locate him. But for
Isn't this a legislative gap? I mean, in all honesty, really, because you have many instances where people who are victims are also witnesses, right?
Right.
A lot of times, the victim, in a very serious case, assuming they survive, is, in many cases, the only witness.
Correct.
Yet, the exemption, as plainly read, allows the disclosure of that person's name, which
Right.
is just as dangerous to that person
Right.
as it is to any witness.
The witness,
right?
yeah. But
So you're really talking about a legislative.
oddity.
Yeah.
Oddity. I understand. However, there's nothing in the statute that says, in this statute currently, or in the new one that's going to take effect July 1st, that says that the witness hat gets removed and replaced by a victim hat. It just doesn't exist. And Sun-Sentinel is trying to...
But you want us to read the statute to say where it says that the name's address of a victim
Gets
is not within the scope of the exemption to mean unless the victim is also a witness.
Or solely a victim. If they're solely a victim, they get the information, yes. But there are many crimes where there are victims and they didn't witness the crime. And I cited those in my nonviolent crimes, typically like a burglary or some type of theft. And someone could break into my home, I'm a victim, but I didn't.
They're still witnesses. They're going to be a witness at trial.
At trial, it could be, but they're not eyewitnesses.
So let me ask you another question. If we find a new statute to be remedial and apply it retroactively, isn't all this debate academic?
It would be. There is no express provision in the statute to apply it retroactively. It does take effect July 1st. And, it's funny, the briefing was completed before all of this, the governor signed it into law. I think it was in May. And so if this case is still pending by the time July 1st comes around, then I think it would apply. I know council will probably say, no, the request was made prior to the enactment, prior to the signing of that legislation.
But don't appellate courts
Apply the
the law in
law.
effect at the time of their decision?
Absolutely. Yes,
So
Your Honor.
if we defer this decision until after July 1st,
It,
the question then be whether or not, even without an express retroactivity provision, the statute is remedial in nature and should be applied retroactively.
yes, and yes, absolutely, because you have to apply the law that exists at the time that you're ruling. But the interesting thing about the new statute, Your Honor, in candor to the court, it doesn't address this issue of once they're a murder witness and then they become a victim, do they lose that murder witness protection? I submit to the
It
court.
says any murder witness is exempt and confidential.
Correct.
It doesn't say unless they're also a victim.
Right.
It's the opposite of what the statute is now. It's the presumption that once you're a witness, it's confidential
Right.
and not subject to disclosure, even if you happen, doesn't have an exception for if you happen to also be a victim.
It does not
So
have
under the
an
new
exception.
statute, the names of these two people, as far as I can see, are not only not subject to disclosure, but they went further and they're confidential.
Absolutely. And I was about to address
We
that.
ask you all to brief the issue of whether that new statute is remedial, since you didn't really
Have the
address
opportunity
it in
to
the
do
brief.
so. We certainly could do so, and I think that would be appropriate because it is such a significant change in the law. It does double down on that protection. It not only makes clear that it was exempt under the public records law, a witness as part of a group of persons in the course of an agency investigating a crime, but it adds that extra layer of protection that Your Honor just indicated, which was the confidentiality. And it adds the 2 years. The prior statute or the other part of the public records law that provides for the exemption does not have a time frame in it that we were just discussing. How long does that active criminal investigation protection exist? Well, now we know from this statute, it's 2 years from the time that they witnessed the murder. Would submit to the court, though, that it really there are 3 reasons that the court can reverse the trial judge's order compelling or requiring the production of the witness information. And it is the chilling effect, which is identified as a public purpose or public necessity required by the Florida Constitution in the new statute. The new statute says, hey, look, we've got this public necessity, and it absolutely identifies the chilling effect if murder witnesses' names were released to the public. That's the first reason why this court should reverse. The second reason is that these witnesses need protection. They need this court's protection.
But aren't those all public policy reasons? In other words, that may
Yep.
very well be why the legislature shouldn't have carved out victims and should have just said anybody who's a witness or victim or who's participating in an active criminal investigation should be exempt until the investigation is done. But that's public policy, isn't it?
But it's also in the statute. It's in the statute currently, not even necessary for us to get to that new statute. The current statute talks about the active criminal investigative information and intelligence information. Investigative information, going to a separate part of the public record statute, defines it as any individual or group of persons that the agency identifies during the course of
Oh, but
investigating.
then I thought it carves out the names of victims.
It
As not being within that.
In a separate section, it does say we are going to identify the names of victims. And it doesn't say in that section of carving out names of victims, even if they're murder witnesses. It doesn't say that. So I think if you read the statute and give plain meaning to the clear language, the intent, and obviously the intent following up with the new statute, is to protect murder witnesses. The new statute is abundantly clear. They're not only going to say, well, we're still doing the exemption, we're going to give you confidentiality, and we're going to add 2 years to this because it's so important to keep our murder witnesses safe. And here, the third reason why the court should reverse is that, as Captain Wallace testified below, it would compromise this investigation. He testified clearly, these witnesses will not be cooperating. We will not be able to apprehend the murderer. We will not be able to turn this information over to the state attorney's office and prosecute this crime. And that's a public safety threat. That could be a public policy, but clearly because it would hurt the rest of the citizens of Florida for a murderer to be on the loose, despite the fact that we have good, solid information based on these witnesses.
You know, even if a person didn't know the law and they were a witness and they came forward and their name was published, there's a good chance that that person, if they were intimidated or they thought they started having second thoughts, they could all of a sudden have a memory loss, convenient
Absolutely.
memory loss. I mean, you certainly could see a chilling effect even if someone didn't know the law at the particular time that they came forward. They might come forward and then all of a sudden change their mind about being a witness.
That's
Or make it difficult for the state to prosecute the case.
Absolutely. There's no question, and that was identified in the staff analysis for the new bill. They referenced a report over in Tampa. A teenage boy had been killed. He had witnessed many murders, and he was walking along the street one day and he got killed. And so the point of, I think, the staff analysis referencing that article was exactly that you need to protect these murder witnesses, and it absolutely has a chilling effect. People do know, oh, Jimmy, who was walking down the street, who had witnessed those murders, he got killed. I'm not going to help the police. So it absolutely has a chilling effect. And I think this court has an obligation and the ability to clearly enforce the public records exemption that exists, that the PBSO, by the way, asserted at the outset. At the very first request for this information, they cited that exemption.
But if we were to write an opinion, for example, that said, because of this compelling public policy, and I agree with Judge DeMorgan and with what you said, it's a compelling public policy. But if we were to write an opinion that said, hypothetically, if you're a victim, but you also happen to be a witness, we're going to put you within the ambit of the statute, right? Then it basically writes away, in a vast majority of cases, the exception to the exclusion for the names of victims. Because in most cases, I know there's that hypothetical possible case, but in most cases, armed robbery, attempted murders, your victims are, in fact, witnesses as well, right?
They are. However, it would, if you did that, you are ignoring, and I understand, it's really which comes first. And I think I had to do a flow chart for the statute.
Could we say that the issue should depend upon whether your primary role
Yes.
is could you write an opinion that would say if the primary role of the person is a witness and they're an incidental victim because they happen to be there, right?
Right.
But they weren't the target, then we would consider them to be a witness, not a victim. Maybe do something that wouldn't open that or eviscerate that exemption to the
Correct.
exception.
Because then you're protected after July 1st. We have this new statute that clearly says these murder witnesses are protected. And yes, Your Honor, there's unrebutted testimony.
But the next case would be an attempted murder, where that new
Right.
statute wouldn't come into play at all, right? 'Cause
Right.
that's just limited to murder.
Murder,
So if your
right.
driver here hadn't been killed, or if Mr. Smith or whatever his name is hadn't been killed,
Attempted murder.
but had been seriously wounded, then these people, under that new statute, wouldn't be protected anyway, because it wouldn't have been a successful murder.
That's true.
So they'd still be
That's
out there
true.
with the same risk, you still have the same public policy.
You would.
Right.
You would have that problem. In this case, Judge Haffel found, and there was no cross-examination of Captain Wallace. He found that, and I quote, "They are primarily witnesses." This was a factual conclusion that he drew based on every testimony, every argument, and Captain Wallace saying, we are looking at them primarily as witnesses.
So we could give trial courts the discretion to look at the totality of the circumstances and determine whether the person whose name they're seeking was primarily the victim
Or the
just
witness.
a witness/incidental victim by being at the wrong place at the wrong time.
Right, and when I was answering Judge DeMorgan's question, these individuals, the two drivers, would not have been victims at all of the ancillary, corollary, ensuing crime had they not witnessed the murder. The only reason they were victims whatsoever was the fact that they were putting on their good citizen, good Samaritan hat and acting as assistants to the police in identifying the murderer, which led to the sketch of this murderer. So they really they are victims, and there's no question. We have not recanted from that, because that's a truth, it's a reality. But they are absolutely primarily murder witnesses, and they only became victims because of the fact that they were murder witnesses.
Okay. I'll give you a minute to rebut, which means I'm going to give your opposition here, you have an extra 4 minutes to add on to your argument if you'd like. Okay.
Dana McElroy on behalf of the Sun-Sentinel. I just would like to start with the fact that there is in Florida a constitutional amendment, Article 1, Section 24, that provides that public records are public, and this is enforced through Chapter 119. In this situation, the Sun-Sentinel asked for victim information. The statute is 100% clear that victim information is not active criminal investigative information under Chapter 119. It is excluded from the definition. So you start with the idea that under the Public Records Act and under the Constitution, Chapter 119 is to be liberally construed in favor of access and to be all exemptions.
So let me ask you a question. Let's assume that I'm walking my dog, right? And somebody in a house kills somebody and they flee and they run out the front door. And while they're running down the sidewalk, they see me, and to get to their car, they smash into me, push me intentionally, and knock me down. It's a battery, right?
Correct.
And then I'm called to the police station, and I can identify the person who ran out of the house and committed the murder, but he also committed a battery on me. You get my name because I'm a victim of the battery, or is my name exempt because I'm simply a witness to a murder?
The legislature has decided. It's not that we get the name or the paper gets the name. And by the way, I just wanted to address quickly, this is a Pulitzer Prize-winning organization, a very responsible organization. It's not an if it bleeds, it leads organization, and has acted responsibly at all times with all information in public records. But to go back to your question, the statute is controlling. And the statute says that where there is a victim, it doesn't say except where that victim is also a witness.
So you would get my name?
I would.
Even though, because I'm a victim to the battery that occurs when the person's running out the house and mows me over as I walk my dog.
That's what the legislature has decided, Your Honor. Okay. That victim information, regardless of how the crime arises, there is nothing in the statute, nothing in the case law. All of the rules of statutory construction say that you must resolve it in favor of the express and plain meaning of the statute, and it is unambiguous. This particular provision was enacted in 1979 as a result of the 1967 enactment of the Public Records Law. And in 1979, and in the Rose case, the Supreme Court said these considerations, these investigative considerations, are always in play. And so in 1979, the legislature enacted these particular provisions that we're dealing with here today. And they took victim information out of the active criminal investigative information exception. And so this is
there any legislative history as to why they did that? In other words, why they would say you can't get any information regarding a criminal investigation except we're going to give you the names of dates and all that of victims. Is there any legislative history as to what was the basis for making that exception to the exemption?
I'm not aware of that. It's not just the victim information either. If you look at Chapter 119.0112, there are 4 sections that are important, and they all come, if you'll excuse me, they all say that these particular categories of information are not active criminal investigative information. And so the very exemption that the Sheriff's Office is claiming doesn't apply by the very and express terms of the statute.
What do we do with Judge Haffel's finding that these people were witnesses, primarily witnesses?
Judge
Does
Haffel's...
that have any significance in our analysis?
It doesn't, and it can't under the Public Records Law, because in every scenario, as the court has identified, in almost every scenario, the witness to a crime will also be a victim. Also in every case. So if the legislature wanted to, and this is where I think we get to the new exemption, which does not change the analysis in this situation in particular, it doesn't change the analysis, because if you look at what the legislature did, they made an express exemption for the identity of murder witnesses. Where it is that they made that exemption was in the general exemptions, it's now 2M, and then also in 119.011 3C5. 3C5 concerns documents or information that are provided to the defendant in a criminal case. They did not go 2 lines up to 3C2 and add 2M to that provision. So in a situation where you have a victim who is a victim of another crime and also a murder witness, the record is public as to the victim identifying information in the statute still and after in July. The only time that that's not the case is when the murder witness is not a victim. That's the way that this court must read the statute as it is constrained to do.
So your position under the new statute would be if somebody went into a home and killed someone and there was a witness, and that witness was also shot, right? That they would be a murder witness within this section, but they'd also be a victim under the other section, and the victim disclosure would trump the murder witness confidentiality? That's what you're arguing?
It doesn't trump it. What you look at is you look at the intent of the legislature in what they did and what they were assumed to know. When the legislature amended the statute, and if you look carefully at the appendix, when the legislature amended the statute, they did not include the murder witness exemption in the victim section, even though it was just as easy to do so. In the victim section, and there are other sections in Chapter 119 that provide victim protections, and those are carefully laid out.
Wouldn't we have to read the whole statute as a cohesive whole? And if there's a part of the statute that says if you witness a murder, your name is confidential, why would we find that another part of the statute that makes you a victim would override that? Wouldn't the more specific section that says if you witness a murder, your name is confidential, control over the general section which says if you're a victim, your name is subject to disclosure?
These are both specific. What the court must do is the court must look at what the legislature just did. And the legislature did not decide. It is presumed to have known that victim information is public record as a matter of constitutional and statutory law. And if you look at again, look to where the exemption was placed. The exemption was placed as not public record because it is an exemption to active criminal investigation information. And so what the legislature did, and it was presumed to have known that victim information is public, it decided not to amend 3A2. And that's very important because 3A5 was amended, and that's when murder witness information is handed over to the defendant or the person arrested. And that's a very important distinction because in that situation, think of how these things play out. A victim is always known to the defendant. Always. Always known.
That's not necessarily true. I sit in criminal now. I have hundreds of cases where somebody's a victim of an armed robbery or victim of a shooting or victim of a drive-by shooting when the assailant had no idea who they were. They just ran up to them in the middle of the night and put a gun to their head or went in a drive-by shooting and killed them while they were sitting in a house or standing outside a car and had no idea who the victim was.
I don't mean the victim in the terms of when the crime was committed. I mean in the process of the criminal proceedings, the arrest, and then in the trial, and then in the discovery. So, and that is where the witness protection came in, and you can see that in the legislative staff analysis, it says there is no protection currently in the statute, express protection for murder witnesses. These murder witnesses that are identified in the staff analysis are not otherwise victims. The only way to read the statute, and it's possible that it's a legislative overlook. It's possible that it is. But you can't assume that and legislate from the bench and say, we're going to add these.
You place great significance on the statute and what it says, and I understand that. But something more fundamental is that Judge Haffel specifically identified these people as witnesses and not victims. And why isn't that significant? Because we're looking at, part of this is a factual determination, part of it's statutory interpretation. But if a trial judge makes a determination and there's evidence to support it that these people are witnesses and not victims, why wouldn't we, what grounds do we have, or what's the basis for us making a determination that they weren't?
There's no exemption for witnesses in the Chapter 119. It comes under active criminal investigation information. And so it cannot possibly be exempt because even if they are witnesses.
This investigation's still going on, isn't it? That's what we heard.
It is, but the definition, and it's important, the definition is very important. It says active criminal investigative information does not include victim information. These were victims of an attempted
But
murder.
it does include witness information.
It does not currently include witness information.
Hold on a second. If it makes exempt the criminal investigation materials, and then is an exception to the exemption, it says it doesn't include victims, right?
Correct.
Then it, by definition, it does include witnesses. Your argument is it doesn't include witnesses who are also victims.
It can include witnesses. Law enforcement agencies are entitled to withhold witness information as part of the statutory scheme if, in fact, they aren't also victims.
Okay, but what Judge DeMorgian's point, as I understood it, was if the trial judge has made a factual finding that these people are primarily witnesses and only victims incidentally, would they not be entitled to the protection of the statute?
The finding is irrelevant because they are victims. It doesn't matter whether they're victims first or second or third. The statute does not allow trial courts or appellate courts, and the Supreme Court has been clear on this, to add words and say except when, for example, the victim is also a witness
Well, in order to
or
apply
primarily
the
a
statute, the
witness.
trial judge has to determine the character of these individuals.
The trial
So if
judge,
the trial judge makes that determination, who are we to say that determination is incorrect?
the trial judge correctly ruled that victim information is not exempt under the statute and that these individuals were
The
victims.
trial judge said in the same breath, but having said that, these people are primarily witnesses.
Witnesses do not enjoy protection under the statute, under the active criminal investigative information expressly. And you must read all parts of the statute. And when in doubt, and this is clear from the Supreme Court many, many times, this court as well, when in doubt, it must be resolved in favor of disclosure. This is a constitutional right. This is a statutory right. Only the legislature can clear up confusion where it might exist.
Let me ask you this. It's interesting you just said something which I think, sitting up here for these number of years, I've come to fully appreciate, and that is, well, you have to, judges, you have to read the entire statute and to get a full flavor and understanding of what was meant here. And I guess then that begs the question as to this new statute that the legislature passed. Why wouldn't we then really not focus in on if it's 2B or 2C or 2E, but read the whole thing? And when you read the whole thing, then you get really an understanding for what the legislative scheme here was in accordance with the constitutional provision.
It's certainly the legislature intended to protect murder witnesses who aren't otherwise victims. That is 100% clear, and I would agree with you on that. But they did not choose to protect them in situations where they are victims. They specifically did not choose to do so. And so you must presume that they were aware of the victim line and that they didn't. Remember, in the victims are protected. If you look at actually what the legislature did, they have 2H is in that provision, and then they added 2M. And 2M is the murder witness protection. They added 2M in 3C5, which also includes, it says 119.0712H, documents given or required to be given to a criminal defendant or a person arrested then lose their investigative character. And so that's where they put the new exemption. 2M was added. 2M was not added 2 lines above that says active criminal investigative information of the victim of a crime except as provided in 119.0712H. 2H is in both subsection 2 and in subsection 5. And the legislature only amended subsection 5 to say, and in that case, the only proper reading is that the legislature intended that the witnesses that don't have another character, that they aren't otherwise victims of a crime. Or you would simply, as you have, I think, recognized, this court has recognized, You would write out a very large category of records that are public, which is only for the legislature to do. And public policy reasons, they are important, and they have been considered by the Supreme Court and this court time and time again. And what the court has said is that it is up to the legislature. And if that were otherwise, then public officials would have the discretion in situations where they deemed information should be protected to withhold
So these
it.
two people would be protected had they not been shot at. In other words, if they had just followed him, got the license, called it in, they would be totally protected. Their names could not be divulged. But because the shooter shot at their cars, their names are now subject to public disclosure.
What if the shooter shot at them first? What if, as you said, the guy didn't die? What if I'm in a bank and I see somebody rob a bank and on the way out he shoots me and I don't die? There are innumerable scenarios that we can think of in cases where somebody is a victim and also a witness. The point is that the legislature made that determination for us. And so, yes, it does matter. It matters that they are victims. They are victims of an aggravated assault here. And when this person is arrested, if this person is arrested, he or she will be charged.
Okay, so if two people had been following him and one person got shot at and the other person didn't, the person who didn't get shot at would be protected under the statute as a victim. Their name could not be disclosed to your client and put in the newspaper. The person who gets shot at is, in your view, also a victim, so their name gets disclosed to you and put in the newspaper. So you have two witnesses in the exact same position, but because one happened to take a bullet in their car, their name gets published in the Sun-Sentinel under your reading of the statute, whereas the other one, who never got shot at, their name gets protected, it's confidential, the Sun-Sentinel doesn't get it, and they don't end up in the newspaper. That's your statutory interpretation.
Well, that's not how I would put it. I would say there's a constitutional amendment that provides that this information is public record. Whether it ends up in the newspaper is irrelevant for the analysis under the statute. If you're a victim of a crime, your information is public record. That's what the legislature has said. That's what the voters said when they enacted Article 1, Section 24. That's not something the Sun-Sentinel claims for itself. That is a public right.
Let me ask just, this is a fascinating discussion. I've got to ask you this, and I'm perhaps carrying it to an absurd level, but I'm just trying to flesh this all out. What if? Well, let me ask this question: when do these guys, these gentlemen who are seeking protection, when do they no longer become victims? When are they no longer victims? When are they only witnesses? In the current scenario, as we stand here today, they are victims, alleged victims. When do they no longer become victims?
The sheriff's office designated them as victims, not the Sun-Sentinel, not the public. So I can't even answer that question.
Okay. So if the state attorney were to say, we're telling you right now, if we catch the bad guy, we are not prosecuting him for these guys. They are not victims.
That's down the road. They were listed, if you look at the incident report, they were listed as victims. They were shot at, and they are the victims of a crime. So
prosecuted or not, I guess is what you're saying, they're victims.
They are victims right now. Their information is subject right now under the attempted murder.
If Judge Haffel had made a finding that they are just witnesses, would you be arguing to us that they were in fact victims?
Judge Haffel found they were victims, and yes,
I understand that. But my question is, what if Judge Haffel had found that they were that shooting really wasn't directed at them? It was just a shooting out of a car, and he made a determination based on whatever evidence was presented below that they were in fact witnesses. There was no evidence to establish that the shooter was attempting to shoot at them.
I would say that that's not what the factual scenario was.
So you'd be up here arguing that Judge Haffel's conclusion as to their characterization, how he characterized them, was not supported by competent evidence. That's what you'd be arguing.
I'm saying that the record as it stands today is that the sheriff's office identified them in their incident report as victims. Judge Haffel agreed and basically got Captain Wallace to agree. That's not the issue before this court. they were victims. They're listed as victims. Judge Havel found they were victims. That's why he felt constrained, and properly so, that their information, the information that's provided in 119 is not a public record. You don't even get to the active criminal investigative because it is public record right now. It's public record because the sheriff's office decided it was public record when they listed them as victims. And Judge Havel agreed with that. He said they are also witnesses, as this court knows. Of course they are. They are witnesses to their own crime and they are witnesses to the other crime, but they are certainly victims.
Let me ask you to wrap it up, because I've given your extra 4 minutes, but if you want to take another minute to clean it all up, and you're good.
I appreciate this
Okay.
court's patience. I would just say that it's important, the statutory rules of interpretation have been in place since the 1970s. This victim information provision has been in place since 1979. For nearly 40 years, this has been the law of the land, and it's still the law of the land today. And this court, if it doesn't agree with it, that it is still up to the legislature to change it and not for the court to engraft words or meanings into the statute.
Thanks.
This court does not need to wait for the legislature. However, in reviewing the amended or the additional statute that comes into existence July 1st, Judge Hansman, you're absolutely correct that it is more specific, and the location of it is significant. It is under agency action, paragraph 2, and it absolutely is more specific and controls over the general, which is in the other
But
section.
you all haven't briefed any of that, right?
We haven't briefed
So
it, that is correct.
So if we were, if we get past July 1st in this case,
It could impact
at the
this.
very least, we should have you all brief, number one, whether the statute's remedial, and number two, even if it's remedial, its interpretation, right?
Correct. Yeah,
Those
absolutely.
are two areas that should be further
Absolutely.
illuminated. I mean,
Absolutely, and PBSO would assert that it is more specific and controls over the general. And if you look at the public purpose behind the statute in subsection 4 of the new statute, it talks about the public necessity of protecting the murder witnesses. What's also important is
Well, it's true, but you guys are arguing just the contrary. She's saying the victim exemption should be limited to, is still out there. They're
Right.
still entitled to victims,
Right.
even if they're also witnesses.
Right.
You'd argue under the witness murder, they're still entitled to the witness murder protection, even though they're also victims.
Absolutely.
So you're
Absolutely.
basically arguing the flip side of the coin,
We are.
depending upon which statute we're under.
We are, and I think
Okay.
Sun-Sentinel agrees, as they conceded below at the trial court, although briefing is a little bit different. And I quote, "If they were just witnesses, PBSO would be correct at this point. Their identities would not be public records. We have no argument about that. It would not be seeking the information." So Sun-Sentinel does concede and recognize that there is an exemption for murder witnesses in the old statute. That argument was made before Judge Havel, and that concession below was made based on the old statute. So it really is the interplay between that section about active criminal investigative information and the definition of the active criminal investigation, which accepts victims.
But your opponent is suggesting, and I'll ask you to respond to this, and we really do need to wrap this up. Okay, so let's call it, for lack of anything more specific, we have a tie here. But in this case, your opponent's arguing the tie goes to the press, or to disclosure, not the press, to disclosure.
Right.
Because the Constitution encourages broad, liberal disclosure to the
Disclosure.
public.
Right,
So
based
why
on the-
wouldn't the tie go to disclosure in this particular
The tie
case?
the tie does not go to disclosure based on the public necessity for protecting the private information, identifying information of these witnesses, not only for their own safety, but for the public's safety at large. The public does not need to know the names of these murder witnesses. The public needs to be protected from this murderer who is still out on the loose.
Is that expressed in the statute?
In the new statute, it is, Your Honor.
Not in the old.
And not in the old. That's correct. And searched
And you would
legislative
agree
history.
that there's a heightened level of scrutiny here because it's in the Constitution.
Constitution,
Disclosure is the preference.
Absolutely, I concede that is accurate. However, the active criminal investigative information does protect an individual or group of persons identified by the agency who is investigating a crime. That means you don't have to have the word witness in that old statute. And that's where we, have that gray area. You don't need the word witness. That is what a witness is. It is a group or an individual identified by PBSO during the course of investigation. They provided the information so that my client could have a sketch and put out information to the public saying, please contact us so that we can arrest this dangerous person. So if there is a tie, it should absolutely swing toward protecting the public from the murderer who we are trying to apprehend and protect these two witnesses, because it would have a chilling effect on not just this investigation, it would obliterate this investigation. It would have a chilling effect on future ones as well. Thank you.
Okay, thanks, ladies. We're going to tell the professors of these law students that this would make a perfect final exam question. This is really a fascinating discussion. Thank you very much. Okay, we'll come down and talk to.
Chief, I'm going to use the restroom. I'll be right back.